Justice Jackson?
Yeah, can I drill down on that a little bit? Because I think that's at the heart of one of my concerns about the burdens and some of the questions that we've heard. So you put on Mr. Trendy at the district court, and my understanding was that Mr. Trendy did not really, as an expert, undercut the methodologies of Ragusa and the other experts. Is that correct? I mean, he didn't put forward an alternative or do a kind of methodological analysis of Ragusa, did he?
He did point out some of the flaws in these expert reports, including this use of total numbers instead of percentages. He also talked about the contiguity issue in the county envelope analysis I was just discussing with Justice Barrett.
But you,
he did.
Oh, sorry. So he did.
He did point out some of these methodological flaws, and we pointed them out also to the district court.
And what if the district court disagreed? I mean, the district court ultimately relies on Ragusa's expertise, and you say that you challenged, although you did not really bring an expert report that met Ragusa at the same level, but you raised the objections, and the district court disagreed, apparently, right?
That's correct.
Okay. So I guess what I'm concerned about is that I kind of hear you wanting us to do a de novo review as opposed to a clear error review, because to the extent that you're now asking us to look at the flaws in Ragusa's testimony and I guess disagree with the district court's crediting that report, that sounds to me like de novo. I understood from Cooper that the clear error standard, and I had it here a second ago, is a highly deferential standard that the court may not reverse just because it would have decided the matter differently. A finding that is plausible in light of the full record, even if another is equally or more so, must govern. So to what extent do we have to credit the district court's disagreement with your objections to Ragusa's report?
It's a great question. Let me give a couple of responses. First of all, as you've just read from Cooper, the court has to consider whether it's plausible in light of the entire record and all of the evidence. And here the district court just ignored other evidence that was put forward. What we are asking the court to do is exactly what it did in Cromartie 2. In Cromartie 2, there was a plaintiff's expert who did an analysis of VTDs moved in or moved out or potentially available to the district. The state also put forward an expert to give the contradictory interpretation of that evidence, but the district court excluded that expert.
Yes, but wasn't there other, I'm sorry, wasn't Cromartie 2 a majority-minority district scenario?
Sure, which again is all the more reason why the racial target theory in this case just makes no sense, because there's no clear motivation.
No, I understand. You're sort of shifting. I guess I'm just so keep going. Cromartie 2, you're asking us to do the same thing.
We had exactly the same situation with experts. The district court had excluded the defense expert, so that expert wasn't really considered by this court on review. But this court went through as part of clear error to ensure that the district court had not relied on clearly erroneous expert testimony and a bad methodology. That's what most of Cromartie 2
But how does clear error work in that? So, like, I understood the standard now, post-Cooper, to be, is it plausible that the district court could have relied on Ragusa's testimony and could have found it to be reliable, and in the absence of a defense expert that's actually poking methodological holes in it, I think you have a hard time. You know, if our burden is just to say, was it plausible that the district court got it right in terms of the crediting of the Ragusa's report?
I don't think that's what exactly what the clear error standard requires.
All right, so tell me what it requires.
Is the district court's finding of predominance as a finding plausible in light of the whole record?
And that includes both the expertise and also the district court's credibility findings, which is another sort of aspect of this that I really wanted to pin down. You say the district court ignored other evidence, but it did have a trial, and it had the actual person who drew the maps come in, and there's testimony in the record where the court itself is questioning directly, not relying on the attorneys, but actually putting questions to that map drawer. And I'm just wondering how we are to assess the court's determination that it disagreed with or didn't believe the expert when he said, I was looking at partisanship and not race.
It was not a credibility determination because the court never based that on his demeanor on the witness stand or at trial. The court credited other evidence, but there was also other evidence the court didn't even discuss.
So are you saying the court could not have disagreed? I mean, they asked him the question, moving that line up into the African-American areas of North Charleston, you would say was for a partisan lean, correct? And the witness says yes, and they ultimately find that that's not so. So why isn't that a finding? I disagree. I don't believe you.
A credibility determination, as we pointed out in our reply brief, requires a determination about the demeanor of the witness on the stand. Otherwise, district courts could always wrap their fact findings in credibility determinations in an attempt to avoid review. They didn't even do that here. There isn't that kind of classic credibility determination. But even setting that aside, there was all kinds of direct testimony from Senator Campson, who was the sponsor of the bill, from Senator Massey, who was the Senate Majority Leader, from Representative Jordan, who also testified about text messages in the record.
So what would a plaintiff have needed? And this is my final question. I'm short on time. What would a plaintiff have needed, in your view? Direct evidence, a statement that says we are using race and not partisanship in this particular area.
That, or an alternative map that disentangled the two, or, if you think the alternative map's not required, a full evidentiary picture that showed that traditional principles actually were subordinated to race. And here there's been no showing for the reasons I just discussed with Justice Kavanaugh.
Thank
a
you.
line in Charleston County complies with traditional principles.
Thank you.
Thank you, counsel.